Good afternoon, everybody, and many thanks for joining us today. This is really a special event for us because we're celebrating our 10th anniversary. My name is Wolfgang Andrea. I'm the owner of Lexion, and I'm very proud that this little something has developed so nicely, EDPL, and I'm really just going to go back a bit. But first of all, of course, my thanks goes to Bart, who is now the editor for, well, most of the time he's been the managing editor and the executive editor Nelly, and of course all the other editors you see up here and everywhere. So it's really great that you're all here. And just going back a bit, 10, 12 years ago, well, the GDPR was slowly but surely coming up, and we had at that time a German yearbook on the Freedom of Information Act. And in this circle, we developed actually the idea. And so we still have on the board Alexander Dix at the moment and Peter Schaar, who were in this circle. And so the idea came up, and then we had Judith Rauhofer. All these names probably don't mean anything to you, but in case, I just want to mention them for just once. And so we started it took quite a while, but it really picked up once Bart really took over. And I'm very proud that we now have this great journal. And yes, and so many thanks and for coming here this afternoon. And actually Bart didn't just, no, I just want to show the cakes, which Bart organized. And so many thanks, and I'll pass on to you. And yeah.
So thank you, Wolfgang. European Data Protection Law Review now exists 10 years, and we're very happy with that. I know when we first met on your initiative, it was at CPDP, and we started discussing, is this like a viable idea? And one of the main things we discussed was, will there be enough content to write about in data protection and privacy law? And I think we all know it just keeps on coming and keeps on giving. And the journal has just grown steadily ever since. I think in particular to Nelly. She has been the backbone of the journal and always behind the screen. She does most of the things, actually. So thank you, Nelly, for making this journal such a success. I also want to thank all of the editors, of course, and particularly Mark Cole, who has been one of the founding members as well. He does the report section for EDPL. Maria Zanu, who does the case notes section, and Gloria, who does the book review section. So very important roles to me. Without them, we couldn't survive this journal. So I will be distributing the cake during the panel because it's a celebration. This year we will do it a little bit different. Normally our session is about the Young Scholars Award, which we do every year. We select the top 5 papers we have received. The top 3 can present here, and the first prize gets the recognition and an award. And this year, because of our 10th anniversary, we have an all-star panel. And that's going to be the majority of the discussion, but we're going to have 20 minutes for presentation and Q&A with the winner of the prize this year. Okay, so I'm not sure whether I need to introduce the panelists still. I'm pretty sure you will know everyone. Wojciech, if you don't know Wojciech, then go away. Eleni and Franziska are very famous professors. Yes. Axel, maybe the least known is... sorry.
What are you saying?
Sorry. In this community,
okay.
is one of the most important European data protection and privacy lawyers. Does a lot in Europe, also in America, works there. And is part of our board as well, kind of overseeing all the practitioners' reports and files we have. So we're gonna basically look back to when the GDPR was introduced and EDPL first existed. the years that evolved, and then look ahead to the next 10 years. But before we do that, just to warm up, Wojciech, Marvel Studios is approaching you. They're saying the next superhero will be EDPS. How will superhero EDPS look like, and what is its superpower?
I think when I was, does it work? Okay. When I was preparing for the selection procedure of EDPS for the next term, I decided to ask the ChatGPT on the stupidest question that you can ask to the candidate for EDPS. And surprisingly enough, that was very similar to the question that was asked here. So what would be the power and what would be the anime figure to be presented by EDPS? Well, unfortunately, I'm not good in the pop culture in this sense, so it's hard for me to address exactly the heroes and exactly their powers. But I think that what the EDPS would be always very good in is to see from inside what's going on in the EU institutions and what's going on among those who theoretically authorize the laws that go from the European Union. So it has to be some of the heroes who has the internal look, and the superpower are the persons who are working for the EDPS. And I would like to stress it very strongly that for all the data protection authorities, actually these are the group of the peoples. These are not the individual DPAs. These are not the members of the Commission. We are reflecting the work which is done by the people inside the institution. So look at them, look among them, the people who really knows how the privacy operates in Europe.
That's going to be difficult for Marvel, but Axel, what is the weirdest question you got from clients over the years on privacy and data protection?
Of all that many weird questions, can you make the GDPR go away? Probably. Quickly and at no costs. Yeah. No, many. I have a big line of other strange questions, which I don't think are so interesting. But of course, I'm coming from a different world, not so much from the academic world, although I publish comparatively much. However, in our world, the GDPR is not the friend. It's often like our clients, they're willing to comply, but they're not so happy to do it. So if they can choose, please tick the box. Do you want to comply? Yes. Do you want a GDPR? Yes or no? Most of them would say no. And an AI Act? No, nothing. Yeah. And that makes it a bit of a challenge for us. As we stand, we are the little bit kind of man in the middle. We are data protection experts, and we respect the law, the GDPR, but at the same time, we need to navigate our clients through their compliance needs, where we can say, well, you have to do this and that. In that area, this year probably take it easy, but next year you need to have a better look. So it's a little bit of gray area navigating in an area which is not fixed yet. And we discussed this upfront, like transfer to the United States. If you take the letter by the law, you should stop it. Now, to China, you need to stop it. However, business goes on. You cannot really stop it. And you had to find that compromise. And that's part of our job, actually.
Thank you. So, Eleni, you had your fair share of publishers and good experience, bad experience. And now publisher is approaching you and saying, well, they translated the Bible into emojis. can we do the same with the GDPR? How would you respond, and how, if so, would you put Article 1 in an emoji?
First of all,
It's an easy question.
well, it's not so science fiction. I'm old enough to remember having very serious discussions, also emerging from the European Parliament, making sure that all rights of data subjects can be icons. Everybody was like, Creative Commons have been a huge success. We do the same, and we educate our data subjects, including children. It was one of the more fun things to do. I mean, we spent a lot of workshops. We were at our young times then. So you had the time to go and discuss, and Gloria is also smiling then. I don't know if you remember. So there was even a draft, and I have it in my laptop, that these were included in official legislative documents. Yeah. So we can write a blog about it and have fun. But it doesn't work because it's all very contextual. Yeah. So I would avoid putting an emoji, especially after watching adolescents, knowing that emojis in younger generations mean different things. So I don't want to go there.
You never know.
So I want to be very careful. Yeah.
Okay, Franziska. Okay, easy question. If Max Schrems were a Taylor Swift song, which one would it be, and can you sing it?
No. Oh my God. The thing is, I really don't know Taylor Swift. I don't know.
Anyone?
I can't sing. That's another point. But I can try to think about it. But I really, I'm too old for Taylor Swift. But
we have to stay young.
Yes,
no,
it's
okay.
true.
Okay.
Sorry, but
then,
do you know any title of Taylor Swift? No. Is anyone in this panel knowing a title of Taylor Swift? I don't even know. But yeah, it's not an easy question, Bart. Please, do you have a proposal, and then I will comment on the proposal.
Okay. Let's go to the introduction of the GDPR. Can you, Franziska, maybe take us back to that moment, like when the GDPR was first discussed? What was actually the problem? What were we thinking this would do?
Yeah, I think, well, thank you, Bart. That's a more academic question, maybe. Yes, I think, well, when we look back, I think we were all younger, that's true, and we had more energy to put into all of the developments. Yeah, we remember the drafting of, I think, Jan Philipp Albrecht and also Ralph, who were really into this drafting. Yeah. The first lobbying fights I survived, I would say, or all of us survived. And I think the big question and the big thing in the GDPR is that the GDPR introduced these high fines and the powers to the DPAs. And I think this is a big, or was and still is, a big change compared to the directive, which was not that enforceable, I would say. And yeah, this was maybe the most important thing for me, surviving this lobbying fight and seeing parliamentarians really into the topic. I think this is also an example we don't see today that much, maybe. Yeah.
If I may share something very personal, I don't think anyone knows, but actually the GDPR was adopted on my birthday and was published on the day I was getting married. So I was there, and I was getting all these text messages. You know, all the data protection community was like, "Oh, did you say this?" It was like I was getting dressed and go to the church. So, yeah, it's fun. For me, it was also, I mean, jokes aside, but it's true. It was also the simplification of the procedures at the DPAs, because I was also quite active at that time in submitting all these applications. Probably, Axel, you remember, with the DPAs not responding, companies going crazy. So in the beginning, we saw it as a simplification. Everybody was like, okay, especially when it comes to sensitive data, we don't need to go into all this very heavy procedure with the DPA. Soon we started questioning whether this was the right thing to do.
Can you pick up maybe, Axel? Because there was a lot of panic also with the market party.
It was a very interesting time for us. Actually, when it started, for me, the key point was the Schrems 1 decision, actually, because the ECJ, I think it was 6th of October 2015 or something like this, for the first time, the ECJ was very, very, very clear And I said, what? I was expecting some kind of oracle. Yeah, you read it and you don't know what it means. But it was very, very strict and clear and said, safe harbor is gone, full stop. Because, and then we realized, oh, something is growing, something is coming, yeah? And then I was a little bit like disappointed in 2016. We thought there's a big storm in the industry, people ringing the doorbell saying, help, I'm not prepared. But nothing happened in the beginning. And I was running around on conferences and I said, well, my guess is it's not good for Europe. It's too strict, too complex. We will be isolated, and United States, China, left and right running across. And I was wrong. In the end, we all know Brussels effect, and it was a super seller, the GDPR. So I had a wrong expectation. I thought it won't work. And then I was very surprised. I think it started in autumn 2017. Then I realized it's like a big thunderstorm coming. People were very, very nervous. The industry was heavily nervous. I was, and that doesn't happen very much for lawyers, I was employing 3 new associates at the same time without having work for them ready, because I was anticipating there will be a huge wave of work, and then it really came in 2018. So it was a huge change to the industry. The first time data protection was taken seriously by companies. Previously, under the directive, it was more like cooperation, negotiation, maybe, can you please? But now with the fines, and that's the main thing, it became mature and teeth, and people took it super seriously. And the very day it it was enacted earlier, 2016, but when it came into force, in May 2018, the phone didn't stop ringing. We had a conference in Hamburg with the DPO, the local one. We had 120 people, and then I had to do it again, and we had again 120 people. Usually we have, for local conferences, like 30, 40 people. So that was amazing, a big change.
Wojciech, can you maybe tell from your perspective, like at the EDPS, like how was the beginning days of the GDPR?
Well, to be frank, for me, the first thing which I remember is from the times when I was the Polish Data Protection Commissioner. So it was the year 2012, where the first draft of the GDPR has been revealed. And surprisingly enough, that was during the CPDP conference. Yes. That was January, but that was the time when the CPDP was in January. And actually, that was the night before, there was a party in the Polish permanent representation, the barbecue for the speakers of the CPDP conference. And I remember everybody was really in the waiting mode. What we will hear, what we will see tomorrow, what parts of the leaked text from November will be really in the draft, and there were only few persons who were smiling in the room, and these were the members of the European Commission who already saw the file. Then the second thing which I remember is the first conference about the draft of the GDPR. Once again, I came back to the program of this conference just a few months ago to find out what was threatening us, what was interesting us, also as the data protection authorities and as the academic community at this time. And surprisingly, I found that the first lecture at the first conference on GDPR draft was about the problems of the procedural administrative law all around Europe, how we will be able to enforce the rules like that in the practice. So surprisingly, that was something which later on appeared to be the big problem. And let me also say one, I don't know if it's an anecdote or maybe that's simply something to remember, that I was sad about the GDPR from the head of the IT in one of the big companies, who said that there were 2 situations last 30 years when the IT guys had all the money of the company to be invested in the new solutions. That was Millennium Bug and GDPR. So Millennium Bug and GDPR were the only things which made the whole treasury of the company open for the IT to invest. I don't know if younger persons remember what was the Millennium Bug, but that was really the scary thing at the end of last millennium.
So then the GDPR was adopted, and we had a lot of discussions in national parliaments, like should we implement it, how should we implement it, how much room do we have to interpret it on our own. You had like the CGEU coming up with a lot of judgments. You already named one quintessential one. You had the data protection officers and supervisors, of course, coming up with their own guidelines, DDPS. Can you, maybe Francisca, take us back to that moment of interpretation? And what do you think are the most important steps there? You already mentioned the blow Schrems 2 did. Can you maybe share one or two of these examples which stuck out to you?
Yeah, I think, well, Schrems is one, but it was before the GDPR, so I wrote the expertise in safe harbor because I know, so it was still the directive, but it had influence, or it influenced the GDPR in a way. Then I would say that in the last years we had a lot of judgments on, let's say, damages, yeah, on how to have class actions, and I think this is an important step. Yeah, this is one of these things which I would say are important. Of course, we have this data exchange with the US, which stays important. Yeah. That's maybe the second one I would mention. And now I think we are faced with a lot of, with all these EU digital laws and all these different acts which come into place. And I think we will see judgments on the interlinks between these different acts. And this will be maybe the next challenge, how to keep the principles of the GDPR still valid in regard of all these EU digital law acts we will see, or we see already.
Yeah, I remember I was very surprised at that time when, many here will remember the Microsoft case. It was a huge thing. We had a very clear case where we had US authorities requesting data from Microsoft Ireland. And suddenly, the Cloud Act, and then we had a bit modification or addition. It was what is now Article 48 of the GDPR. And I was actually very surprised to see how a specific incident, because it was not a case that was actually decided in the end, it was bypassed, made it to the GDPR in a way that we thought can probably solve problems, actually creating problems, because now we get the companies, I guess you've seen it much more, saying, well, we have Cloud Act here, and then we have the Article 48 of the GDPR saying exactly the opposite. What do we do? So I was actually quite surprised on the way how Europe reacted to this issue, and it is a trend that goes on. We tend to act unilaterally. I mean, the Brussels effect is something that we consider as positive in many cases, but in terms of compliance of companies with rules and regulations makes it very difficult.
Yeah, where to start and where to end. When the GDPR came into force finally, in the beginning, people thought it's data subject access requests, which matters, but it didn't. So it was a very ordinary compliance. People started too late, so nobody was prepared in 2018 with all the, let's say, homework you have to do, like having a ROPA in place and all that stuff. So we did this a lot, and the big topics had been indeed Schrems 2. Not Schrems 1, Schrems 2, data transfer to the US, transfer impact assessments. There had been investigation. I mean, the authorities usually, they work reactive. Someone complains, and then they set up a case because they have to do it within 3 months. Every now and then, the authorities over the EDPB have a kind of, proactive action together. And one was an investigation, how are you handling data transfers? So the authorities are sending out letters to like 50 companies for each country and ask for compliance. And that was a big thing, making people very nervous, creating a lot of work. And then another topic, probably under your radar, cookies. It has two parts, e-privacy part, but also a GDPR part. That was big, at least in Germany. And you mentioned earlier, and this is something what I see, everything around Article 82, yeah, because at least in Germany, it's a case law called Deutsche Wohnen was super important because the authorities had established their fines in a way that they kind of ignored the national administrative laws, and they went directly out of the GDPR. They said if the GDPR is infringed, you can fine. However, our national law didn't allow that. And that was really like a very, very important decision, Deutsche Wohnen, because if they had decided otherwise, all fines, at least in Germany, who had been pending, were null and void. But then it went direction to pro-GDPR, and we see this, all the big, let's say, funding companies who support class action and mass claims. They're really waiting for the big business, because now it's like this. When you have a data breach, Article 33, and data leaks out, you have specialized smaller boutique law firms who are funded, and they say, hey guys, have you lost your data in that scandal? You can make 2,000 euros. Come and give me your claim. And this is a big business known in the US already, in the common law world, not so much known on the continent, and that's in kind of preparation. Yeah.
Well, Schrems 2 is probably the judgment that we all will agree was important, but apart from that, everybody of us will say about different judgments. And that is also something to take into consideration. The number of the judgments from the Court of Justice is incredible in comparison of what's going on before. But we have to remember that if we divide this 25 years of this millennium into two parts, so in the first part, in the first 12 years, there were 14 judgments from the Court of Justice of the European Union on privacy matters. And in the second 12 years of this 25, there were 115 judgments from the Court of Justice of the European Union. That's why we have all to choose from. All of us can say about the other judgments. But anyway, for me, probably one of the most important things which happened in the judicature in these years were not the judgments, but the famous last, I guess, opinion from the judge, from the Advocate General Bobek before he left the court.
Can you elaborate?
Let's leave it for everybody as the homework.
Okay. So we're already moving to a bit of criticism. Maybe we can discuss a bit like where our hopes were not met. Like we hoped the GDPR would change things, and it changed a lot of things, I think, for the better, but also on certain points it did not. So maybe you can reflect on that and what should be changed either in the GDPR or in the implementation to solve that problem. Can I give you the floor?
Well, yeah, maybe I limit it to one comment. I still think that these procedural rules are very important and not yet harmonized. And yesterday, apparently, we saw this failure of the trialogue on the procedural regulation. I think this is an important part to go forward, to have some kind of really EU procedural rules and data protection to go forward, but not maybe in the way it was proposed. Maybe it needs some changes. But I think this is something which which was maybe on one part a bit disappointing, because I thought it would create this kind of procedural law, and it didn't. Yeah, so maybe it's coming now. This is maybe, well, I limited to that. Otherwise the others won't speak.
Wow. I'm not prepared for this. I can, think of so many.
You can skip. But
No. I mean, the problem is to select. It's exactly the opposite. So I would say one of the things that I haven't decided if it's good or bad is the principles. So I understand that the principles is one of the most important elements of the GDPR. If you do research on the on how many articles and books have been around, they are very limited compared to the importance of the principles. If I criticize the principles thinking, well, they're so general that it's all a matter of case-by-case application, specifying, etc., contextualization, then I don't have a better alternative. So here I am saying that I believe that the principles are essential, but I'm not sure if this is the best way to go forward. I don't like the procedural aspects. Like when the GDPR came in, everybody was talking about the tick box regulation, if you remember. And there were a lot of forms that were developed in consultancy firms. A lot of them flourished exactly on the need of companies to ensure compliance with the GDPR, so they try to make it as procedural as possible so that it's easier to check also for in case of audits. But my main concern, and that's something that I'm trying to think a lot about lately, is the principles. Like, the principles do make sense, but it is very difficult and very vague if we leave it completely in the end to the courts, because that's what's happening. And the reason why I say this is because I was recently reading the statement of the EDPB on age assurance, where they actually tried to implement the basic data protection principles on measures on age assurance with regard to processing of data of minors in the context of Article 8 of the GDPR. And I was like, really? Is this the best we can do? So I'm kind of skeptical. I would like to see more research in this direction.
yeah, very much agree.
I think one of the main obstacles, and I have actually no solution for that, is the complexity in some regards. What I see that people, even DPOs and people who should know, don't understand the very first initial things, like that it's about human rights. And I think it's extremely important always, if people think it's something technical, data, I do like IT, but it's not. It's about protection of human rights. It's not really understood what personal data means, that it's that you have like information from yourself, you give them away and they're unprotected somewhere in the world, and that the lawgiver, its task is to protect that data, which you cannot protect by yourself because you don't know where it is. These very basic principles are not transported still. And from a legal perspective, that the GDPR is a general prohibition where you need to look for justifications. People who are working with the law, they're not used to that. They're looking for prohibitions. Yeah, they look. What is? They think I can do what I like if it's not prohibited. But GDPR is the other way around. I think it's right that it is like this, but this makes people's mind slip out, and then that's what I see when I have scholars and trainings with employees. That's where you lose them if you then catch this at the very beginning and start. And because many people, even though who work for 4 years on data protection, who don't inherit the basic ideas, they will never get it. That's one problem. I think it's education at that stage. And then we have some rules which are like not practical. I don't want to have tick the box solutions or icons. That wouldn't work. But just to give you one example, if you have you are the controller and you're privileged in a way if you work with a data processor. Yeah? Therefore, you have data processing agreements, DPAs. But that's a privilege because you're still responsible. You have a contract so that the processor can do things. However, if you transfer data to another controller, this is from a GDPR standpoint more crucial because this new controller needs an additional justification. However, there's no contract. So people don't understand. They want a contract. Yeah? And then when I say, well, this is not really a data processing transfer, you don't need that agreement. Yes, I want an agreement. And you have to think about more practical. We should have also an agreement if you have, for example, transfer from one controller to another. And there are many, many examples like this where it's just not practical for those who need to implement it.
Whatever EDPS will say about the change of the GDPR will be taken against him. So if I was an American citizen, I would say I take the Fifth Amendment and decide not to self-accuse.
Okay, fair enough. The final question, we are now 10 years from the introduction of the GDPR and EDPL existence. Where do you think we will stand 10 years from now? And we're not fortune tellers, but give us an idea of your perspective on 10 years from now.
Okay, not with Taylor Swift at least. I think, 10 years are a very long time in information law. I think we saw it, when we reflect on it. I think we will still discuss the basic principles. Unfortunately, we are maybe then 10 years older. But we might see different technologies, and we have to adapt these principles to these new emerging technologies. I think this is a challenge we will have to face. Stick to these principles or develop these principles further, because I think we didn't develop these principles further. Yeah, we are still roughly at the discussion where we were maybe 10 years ago, 5 years ago. So we have to develop, maybe for me it's a challenge, to develop these principles to emerging new technologies. Yeah, this would be my take.
I need to correct you. These were drafted in 1990. So
Taylor Swift was not born in that.
Yeah, indeed. So I don't know, I may fail completely, but I see the GDPR in the context of EU regulation. So we are over-regulating at the moment. So there is a moment that I think, I'm afraid this will all break. Then we need to rethink everything from the beginning. What we have now is quite a complex matrix of rules. I'm old enough, she implied, when we started working, there was only the Data Protection Directive. When we were writing our PhDs, it was the Data Protection Directive, and you had this framework decision, and you are one of the 10 people in Europe that know about the framework decision, yoo-hoo. And now, poor PhD students in this room, they have so many legislative instruments that I need to go through, extract relevant provisions that touch upon data protection in incredible pieces of European legislation in order to have the full picture, which makes it way too complex. And experience shows that when this goes over a breaking point, you need to rethink about it.
So we're heading towards one
I
super
hope that
law,
at some point, not necessarily a super law, but at some point there will be a need for simplification. We have seen the same trend at national levels, right, throughout Europe. And European Commission, I think, was holding back. And now, for some political reasons, they have completely changed their attitude towards legislating. We move from all the directives to complete compliance with regulations, which doesn't make any sense because in the end we have regulations with so many exceptions that are semi-directives. I'm not sure if this is the right way forward. So my expectation would be that in 10 years' time, we will be mature enough to say, okay, this is way too complex, what makes sense, what doesn't, and have probably 3 or 4 laws relating to online services, processing of data, transparency. I don't know what it will be. I hope.
it goes into the same direction, but I wonder if you really can start from scratch and throw away everything. I don't think so.
No, definitely not.
But I think the European Commission has made a fundamental mistake with the new EU digital strategy. I think it's correct. We are entering a new digital area, and we have a ex ante regulatory approach. So we want first rules and then we do business, not ex post like in the US. They move fast, break things and then regulate. Yeah. However, we have this idea. We want to regulate first, and then, and now I'm coming to the mistake. And both of you already mentioned all the new EU digital laws, Data Act, AI Act, DMA, DSA, DGA, NIS2, so cyber laws, e-privacy still unsolved. So many new digital laws. However, those laws, to my big surprise, had been developed completely in silos. So nobody was talking to each other when developing this. And in particular, nobody was talking to the GDPR guys. Yeah, so when I talked to authority experts and leaders, they said, no one talked to me. So what is the consequence? If you read these new laws, and you all need to have a certain overview because they interact and they will interact a lot in future. You just see one line, AI Act. And the GDPR remains untouched, by the way. Or in the Data Act. And the Data Act has the Data Act says exploit data. We say minimize data. So completely conflicting ideas. Yeah? But the Data Act doesn't say, now I'm solving the conflict with GDPR. They just say, you need to take into account GDPR. And that's not good, because now, instead of solving these issues between the tension between the new laws, every company has to do it on its own. This is super ineffective. So to give you an example, these glasses are smart glasses, yeah? IoT, Internet of Things. You have at least 3 layers of regulation. Yeah? You have if you want to exploit the data, you have the Data Act. Yeah? If there is an AI driving the data you collect, you have the AI Act and the AI law. And because I'm looking at you, it's personal data, you have the GDPR. So you have 3 thick layers of digital laws. And nobody tells you how they work together. They only say, it all applies. And that is, I think, a fundamental mistake. And that is what creates this possible breaking point. And I see that with my clients. Yeah, we have in-house lawyers. We are 100 lawyers among Taylor Wessing doing that stuff. And we are already struggling, although we have know-how experts and marketing whatsoever support. What is an in-house lawyer on his own or on her own, having all that on the desk at the same time? Impossible, not possible. Yeah, to read the law, to digest the law, plus do this interconnection. And I'm looking for this, I want to give the law back and say, hey guys, it's a good idea to do it, but you need to add how they should work. That means for GDPR, all those new laws should have a section like, if implementing that law means you process personal data, here is your justification. So not only Article 6, and not only Article 6(1)(f), yeah, you need some explicit wording in that new law explaining how that works together. And that's a link which is missing.
If you try to look how it will look like in the decade, I think I'm the closest to Eleni. But when I think about the laws which will vanish, or will be changed, or will be recalled, I don't think GDPR is among them. GDPR has one specific feature, and that's the paragraph 2 of Article 16 of the treaty, which says that this wonderful fundamental right, which is written in paragraph 1, which is the right to protection of the personal data, is explained in the secondary legislation of the European Union, And this means actually that what does it mean? It says in the secondary legislation, and GDPR is the one. And GDPR is the basis for that. So I think that we will get rid of many of the new acts that appeared last years, but GDPR will stay surprisingly untouched in these 10 years.
Thank you. We have room for one, maybe two short questions, or remarks, if there are any. Okay, two. Just.
Thanks for this moderating panel. I mean, it's fantastic because it brings me back to the days of the negotiation of the GDPR, the days of Jan-Philipp Albrecht and his team, working on this fantastic law. And there was actually a movie made, in Rush der Taten, like this documentary film. But many things, things that are in the GDPR that many advocates actually advocate for many years. For instance, like, privacy by design, privacy by default. I remember Anka Bukian and all these people from Canada and also, the data protection authorities from Holland were advocating this during the 90s. And then we became a reality in the GDPR. It was for the very first time something like, oh, wow. Obviously, there's room for interpretation and still a lot of things that need to be explained. But we have the European Data Protection Board, which the main role is to actually provide consistency. But I believe just a brief question. I mean, it's, do you believe this new review of the GDPR would be actually feasible in view of all these legal changes and these amounts of laws that were coming, like the Data Act, now the UAI Act? How are they going to be, how do you call it, not harmonized, but in a way to interoperate? That's my question.
That was not a short question, but it was one question. Does
I have one,
a short answer?
Yeah, a short answer. I think, and that's the good side with the GDPR, I think the level of being a comparatively generic and abstract piece of law, it allows certain flexibility so that it will survive. Other laws are more specific. AI Act, for example, where I'm not sure if they can survive because they explain too much. GDPR has flexibility in Article 6F, for example, in other, like the German Civil Code or the French Civil Code, they're very, very old, but they still exist because they are allowing that new developments are still, let's say, covered by that piece of law.
Okay. Please give an applause to the panel members. Thank you so much. And please give an applause to the winner of this year European Data Protection Law Review Young Scholar Award, Suzanne. Come. So, Suzanne is my colleague. You're going to give a presentation of your paper. Then we have like 5 minutes of questions or remarks from you. Congratulations again. The award will be handed afterwards by Axel, who was a jury member on this panel. I think you have a PowerPoint? Yes. Yeah, perfect. Is there a clicker?
Are we staying here?
No, we stay here.
Do you want to hand out or stand there?
I think standing is easier.
Would anybody want some cake while I'm doing while we get set up?
Okay, I will get started and hopefully this mic works. Yes, you can all enjoy some cake. So as part of my PhD research, and my PhD research focuses on the interplay between data protection and cybersecurity, I delved into Article 32 of the GDPR, and from that came this paper, and it's called scrutinizing the interplay between cybersecurity and data protection, a paradox hidden behind the state of the art. And as a kind of starting point, I will talk about this dual dynamics between cybersecurity and data protection law. And they're often characterized as two sides of the same coin, or as mutually reinforcing, with encryption, for instance, that's good for both data protection and cybersecurity. And not only is security a key principle of data protection law that has stood the test of time, it is also sometimes posited as part of the essence of the fundamental right to data protection. And at the legislative level, we see a lot of complementarity between data protection and cybersecurity. However, if you look under the hood, the relationship between the two is not all smooth sailing. Importantly, the manner in which cybersecurity is pursued in practice may pose risks for data protection. And then you kind of get that these complementarities and synergies between cybersecurity and data protection that are expressed at the legislative level, they may not hold at the level of technological implementation. And this is kind of what I looked into when it comes to Article 32 GDPR, and kind of also peeking below the surface of this article. Well, I'm guessing almost everyone here is quite familiar with what this article says. I will nevertheless do a very brief recap, also taking into account recent jurisprudence we've seen on this article. And that was quite exciting. I think it's by now 2 years ago, the Court of Justice for the first time actually had a proper Article 32 GDPR case. And they confirmed that effectively Article 32 GDPR establishes an obligation of means rather than an obligation of result. So the GDPR establishes a risk management system intended to mitigate personal data breaches rather than pretending that we can eliminate them altogether. So rather than requiring perfect cybersecurity, Article 32 GDPR obliges both data controllers and data processors to implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. However, little to no guidance is given to assessing security risks, but more importantly, to identifying appropriate state-of-the-art TOMs. I will just call them TOMs instead of having to constantly say technical and organizational measures, which is a bit long. So the data controller and the data processor are left with a great deal of discretion when it comes to implementing technical and organizational measures. We can find some minimum guidance in Article 32 GDPR and some key criteria to be taken into account. As you can see, state of the art is one of them, next to cost of implementation and the scope, context, and purpose of the data processing operation. So before diving into what actually is state of the art, I will first relate this back to the broader picture. And this broader picture has to do with technology neutrality. So the regulatory approach of relying on state-of-the-art technical and organizational measures is an embodiment of technology neutrality. And at first glance, it makes quite a lot of sense to have such technology-neutral notions, as it helps the law become more future-proof and kind of prevents it from being outdated or ineffective too quickly. However, there's also quite some criticism when it comes to technology neutrality. And one of them is the lack of legal certainty, and another one is that it makes technology invisible. So kind of technology is disappearing from law that regulates technology. And especially this disappearance of technology from the law is problematic for determining the interplay between cybersecurity and data protection, especially in the context of Article 32 GDPR. What I try to do in the paper is to get to a bit better understanding of what is state-of-the-art in the context of Article 32. So it's often said to be an elusive, open-ended, abstract, and general notion, or it is referred to in terms as technology neutrality, market-based, and dynamic. And I try to sketch a bit more of a tangible interpretation of what state-of-the-art is, and to try to identify some actual technological cybersecurity tools that could be considered state-of-the-art technical and organizational measures in the realm of Article 32. And to do that, I looked at a whole bunch of different sources. including the German Federal Constitutional Court Skalker decision, guidelines by epistemic authorities such as the ENISA Teletrust guidelines, enforcement decisions by DPAs taken in the context of Article 32, jurisprudence by the court, which did very little to illuminate the matter, and also the notion of state-of-the-art as it pops in other areas of the GDPR and in cybersecurity legislation. And this helped me identify some specific cybersecurity technological solutions that could be considered state-of-the-art technical and organizational measures in the context of Article 32 GDPR. And I listed some of them on the slide. There are definitely more, but some examples are encryption, the retention of log records, access control mechanisms, such as multi-factor authentication. And the one that was especially interesting for me in my research was network intrusion and detection systems. So in general terms, network intrusion detection systems aim to improve cybersecurity by monitoring and analyzing network traffic and retaining logs, identifying potential threats and malicious activity and retained data, and providing alerts about suspicious observations that could indicate that there's a breach or a cybersecurity incident taking place. And network monitoring is often reliant on deep packet inspection technology. And deep packet inspection technology allows the inspection not only of metadata of packets traveling across the network, but also the inspection of sent content. And this DPI technology is often said to interfere with data protection and privacy. So at the technological level, we start to see that cybersecurity solutions may conceal a compromise or trade-off between the various protection objectives. For instance, anomaly-based network intrusion and detection systems at the technological level, a balancing act takes place between, on the one hand, the protection of personal data, and on the other hand, the amount of potential knowledge created from information to create valuable alerts that are understandable by end users, which is the goal of such a system. And the invisibility of technology in the law, due to its reliance on technologically neutral notions such as state-of-the-art technical and organizational measures, hides this trade-off that is happening at the technological implementation level. In the paper, I explained that this leads to a sort of hidden paradox. So below the surface of Article 32 GDPR, hidden behind a veil of state-of-the-art technical and organizational measures, lies a paradox whereby cybersecurity tools that are implemented for the protection of personal data may at the same time pose a risk to data protection. So in order to safeguard data protection is at the same time put at peril. This is one of the main findings of my paper. And then I identified a second issue relating to this open-ended notion of state-of-the-art technical and organizational measures and the lack of guidance that we currently have when it comes to what are legally required cybersecurity risk management measures. And this other issue has to do with non-material damages. So in the recent case law around Article 32 GDPR, we also see that a broad notion of non-material damage is being put forward, whereby the fear, anxiety, and emotional distress experienced by the data subject may constitute non-material damages. There's still some other conditions laid down in case law that also need to be met. It's quite a broad definition of non-material damages in the context of personal data breaches. This sits uneasily with the fact that data controllers are left with quite some legal uncertainty when it comes to what are state-of-the-art technical and organizational measures. So whilst this broad interpretation of non-material damages will help data subjects find redress for personal data breaches, it also risks personal data breaches becoming very expensive for data controllers who are left with a lot of discretion and little guidance on what are good security measures to implement. So in conclusion, really went below the surface of Article 32 GDPR, and I tried to find out what actually are state-of-the-art technical and organizational measures in the context of Article 32 GDPR. And in doing so, I found that there might be a paradox hidden below the surface, whereby we can implement cybersecurity tools with a view of protecting personal data, but at the same time put data protection at risk. And this raises important questions about the complementarity between data protection and cybersecurity. Not to say that these can't be complementary, but there is a tension happening at the moment which needs further attention and research and guidance. And I also highlighted in the paper that it's crucial to bring back attention to the technological level in order to see what is actually happening between cybersecurity and data protection. And I think shedding light on this paradox is an important first step to ensuring that a proper balance is struck between cybersecurity tools and cybersecurity tools that need to process personal data to effectively identify and prevent attacks, and on the other hand, to mitigate potential risks through data protection. And at the moment, the level of interference with the right to data protection is left to a market-driven process due to this reliance on state-of-the-art technological and organizational measures. But we need more explicit design choices to kind of make sure this goes in a direction and that cybersecurity and data protection can be complementary also in practice. Thank you.
Are there any questions?
Thank you. Thank you, Suzanne, for your presentation, and congratulations for the award. Just a very short question on the conclusion. So what's your take on how to actually reconcile data protection and cybersecurity? I have investigated this quite extensively in the last years, and I too came to the conclusion that cybersecurity most of the times is instrumental to data protection aims, but oftentimes can also infringe data protection fundamental right. And I do recall an article of Mireille Hildebrandt from 2019. She separated trade-offs and balancing exercises, whereas trade-offs lead to zero-sum games, and balances exercise actually envisage, so in a context where the higher the infringement of a measure to a right, for example, data protection, a measure being DPIs, as you analyzed, the more the guarantees we have to put in place, for example, through other technical and organizational measures. Have you investigated in your paper countermeasures to the measures, cybersecurity measures infringing data protection? Or it's perhaps for future research, I don't know.
Thank you for the question, and that paper sounds very interesting, so I'm sure to look it up. I haven't looked at countermeasures on how to do this. I think an important first step is kind of clarifying that this may happen, and especially also because now it's kind of very much left to the market of what are state-of-the-art technical tech tomes. It's easier to say. So I think there's also, it's not the only option that they are, that there is a trade-off. I think I'm kind of maybe very hopeful that technologies, cybersecurity technologies can be designed that take data protection into account from the beginning and make sure that the adequate risks and safeguards are there. But yeah, that would require further research.
there are countermeasures, DPIA, and actually those, they call it the data cybersecurity measures had been put on so-called blacklists by at least the German data protection authorities. I also think EDPB. So you recall 2019, there had been those blacklists. What measures require a DPIA? And one prominent item were the so-called data loss prevention tools. And this is what you're referring to. Tools going, for example, to the inbox, scrapping all data, organizing, scrutinizing is so. The countermeasure is in the GDPR and it's the DPIA.
One final question or remark? Yep. Please, short.
Yeah, thanks. So I was wondering how you see the role of research, in particular computer science research, in advancing the state of the art, because it was always like the market determines state of the art, but actually we computer scientists try to do that too.
Yeah, I think what I saw in my research is that they refer to the state of the art when it comes to like technology and research, and the state of the art once it enters the market, which is what they refer to when thinking about state of the art technological and organizational measures. But of course it goes from research is the first step, and then once that is tested and trialed and enough, then it enters the market, then it becomes part of the state of the art in this context. So I think computer science research has a very important role to play, because also this focus on the importance of technology, we can't all do by ourselves as data protection lawyers. There's a limited amount of knowledge you have as a lawyer on how these computer systems work, and I think therefore it's very important that computer science also works on these problems and use all your knowledge to find out ways how to kind of reconcile the two and make sure that we don't unnecessarily endanger data protection when trying to protect it. So I think that's very important, because then at some point, when those are tried and tested enough, they will enter the market and become available for ordinary data controllers. So yeah, I think they have a very important role to play.
Okay, now on behalf of the jury, Axel is gonna give you the award, which is fitting because all jury members really liked your paper, but Axel liked it even more. He was really a fan of the paper.
I was a big fan of your paper. Susanne, congratulations. It was not only extremely well written, but she really picked up a problem. And maybe you have been aware that what she was just presenting was discussed among us in the beginning, because what we're discussing is how all these laws working together. And here we have the clash between cyber laws saying you need to protect your environment and data protection laws. And you spotted that. So you spotted this potential conflict, you called it paradoxon, yeah, that at the one hand, you need to protect data, but at the other hand, on the other hand, you put this on risk. And I find this, that's of highly practical importance, what you saw. Plus, what you did not present, but that was my super favorite, you were the only one so far, and I discussed it with lots of people who've at least found what I was looking for the whole time, a justification for data processing in one of the other laws. Because Susanne spotted in the recital number 121, at least someone tried, who was drafting the NIS2 directive, at least someone tried to find a justification to process personal data in that recital 121. And I can tell you, I asked several data protection authority leaders, do you know that recital? They said, no, nobody knows, but you spotted that, and that was great. So congratulations.
Thank you.